You what? I mean, let me see.
Okay, go ahead. I'm too short. I gotta go to CC3 real quick.
Okay, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court this morning for what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and the options that you have concerning your case. Now, the case that you have in this court, it is a criminal case. It's a misdemeanor criminal case. Criminal cases are divided into felonies or misdemeanors. Now, your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of life in the state penitentiary or life or 99 years in the state penitentiary. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishment because, as I mentioned to you earlier, your case is a misdemeanor. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. The Class C misdemeanors are cases that start or originate in the JP court or the city court. They come to this court when a person is found guilty or they plead guilty no contest in the JP court or the city court, and then they appeal their case. In essence, they want a new trial, and they get what we call a trial de novo. That's a new trial. And so when the case comes here, the punishment range is the same. Now, the punishment range for a Class C misdemeanor is a fine only. You cannot be given jail time. The fine cannot be above or exceed $500. Now, however, if you fail to pay the fine, or if your fine was converted to community service and you fail to perform the community service, then the court can issue what is called a capias pro fine. What that means is it's a warrant for your arrest for you to either pay the fine or sit the fine out in jail. And if you sit the fine out in jail, you will be credited $100 that will go towards your fine and court costs for every 1 day that you spend in jail. Now, just an example of a Class C misdemeanor, would be not having your seatbelt on, or speeding, or having a suspended driver's license. Those are class C type misdemeanors. Now, the next highest misdemeanor is a class B misdemeanor. Now, the range of punishment for a class B misdemeanor is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a class A misdemeanor. And for the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, just for an example of a class A misdemeanor, would be an assault. You know, somebody hit someone, it could be a family member, or it could be somebody else who is a non-family member. That's an assault. Or you could be carrying a weapon. We call it unlawfully carrying a weapon. Those are examples of class A misdemeanors. Or it could be your DWI second. First, the second time getting the DWI, or you have a DWI where the breath test or the blood alcohol concentration level is 0.15 or more. Those are examples of class A misdemeanors. Example of a class B misdemeanor would be criminal trespass. In essence, you own somebody's property without their permission. Okay, now everybody here should have a clipboard. Everyone that's here for a case, you should have a clipboard. And the reason why you should have a clipboard is because I'm getting ready to go over that clipboard with you. You don't have one? Okay. Okay. Who all needs clipboards? Oh, raise your hand.
They got different.
Should be, okay. We need another one. We need 2 more over here.
They don't have any behind you?
Okay. Hey. And what we're gonna do, once the other individuals get the clipboards, I'm gonna go over this clipboard with you now. The first document we're gonna go over is that first document that's titled Judge's Explanation of Rights to Defendants Without Attorney. Okay? No, I don't say. You got something to add. Here. That's what the paperwork is. Yeah. You can use that clipboard over there. I only had about 20 of them. Yeah, those two right there next to each other. You have a pen?
Huh?
Oh, you don't have a clipboard? Oh.
They don't have any more in there.
Yeah, I'm gonna get them. Right. We get about 20 of them. She's gonna go next door and get it.
But they all have the paper, Jared, so you.
Yeah, okay. So in the meantime, what I'll do, I'm going to go over paperwork with you. Now, the first document that we're gonna go over is titled Judge's Explanation of Rights to Defendants Without Attorney. The document looks like this. Now, I'm going to keep referring back to this document as we go along. Now, this document states that as a defendant in a criminal case, you have three options. That is, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, the first one sentence paragraph under number three states that if you want an attorney and you have enough money to hire an attorney, you may request, well, if you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Reset means you'll be given another court date from today to give you time to hire your attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request or ask that an attorney be appointed to represent you. But you must first sign an affidavit of induce, or you must first sign a document that we call an affidavit in, it's a financial questionnaire. And on that document, you have to sign it, and the document looks like this. Now, this is only for people who will be applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't need to remember anything that I'm getting ready to say. Okay. For those of you who will be applying for a court-appointed attorney, you would have to fill out this document that's titled Jefferson County Affidavit of Injuries or Affidavit of Injuries. You would have to fill out the entire first page. And then you'll go to the second page. And at the top of the second page is titled Defendant's Oath. Defendant's Oath. You would have to fill out this section that's titled Defendant's Oath. And then you'll go to the middle section and you'll fill out the section that is titled Unsworn Declaration by Defendant, and then you'll stop. Okay, that's only for people who will be applying for a court-appointed attorney. Now, going back to the first document that's titled Judge's Explanation of Rights to Defendants Without Attorney. The next one sentence paragraph, the third one sentence paragraph is for individuals who will be representing themselves. That is, you have a right to hire an attorney, but you don't want to hire an attorney, you want to represent yourself. You have a right to do that if you want to do that. Now, if you decide that you would like to represent yourself, you will have an opportunity to talk to one of the prosecutors that are here in court. Actually, we have three now, but we have four. And you'll have an opportunity, and these are the three prosecutors. That is, they are assistant criminal district attorneys. They work for the Jefferson County District Attorney's Office. Okay, we have Attorney Fred Vernon. We have Attorney Andrew Hubel. We have Attorney Barry Nixon. And we had Mr. Jeter, who stepped out. But you'll have an opportunity to talk to one of them to see if you can work out something, a settlement on the case. The settlement is what we call a plea bargaining agreement. Now, the reason why you'll have an opportunity to talk to them about your case because you will be representing yourself. Just like a lawyer can talk to them about your case. If you had a lawyer, you can talk to them about your case because you are your own lawyer. Okay? So you have an opportunity to talk to one of the prosecutors. All right. Now, this paragraph in block form, this is for individuals who will be representing themselves. It states, be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities related to military service, possession of firearms, housing and public benefits, child custody, immigration status for non-citizens, and employment. And this last one sentence paragraph below that states that if you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, now, a person can, I mentioned to you about the punishment range, but I didn't mention to you that a person can be eligible, may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation, and the other one is called adjudicated probation. So you have unadjudicated probation and adjudicated probation. The difference between the two is as follows. With unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the unadjudicated probation, the case will be dismissed, and you can get what is called a non-disclosure. Non-disclosure is where your record will be sealed to the general public. That is, the general public cannot have access to your record if you have a non-disclosure. Now, the operative word that I use is general public. Now, the government can't have access. For example, the police department can't have access, but the general public, which is most of the public, cannot have access. So if you have a non-disclosure, you apply to the job, ExxonMobil, your criminal background check, guess what? It's sealed there. They cannot have access to it. So, now the other type of probation is called adjudicated probation. With adjudicated probation, it does result in a conviction on the record. However, there's something that is called judicial clemency, where the judge can set your conviction aside, and you will no longer have a conviction. Now, in order to qualify, three things has to happen. First of all, you have to successfully complete the probation. There cannot be any more time left on the probation, and the probation department has to successfully discharge you or let you off of probation. If those three things happen, then the judge can set your conviction aside and you will no longer have a conviction. However, if you get a subsequent conviction, that is, you get a conviction, another conviction later on, we call that a subsequent conviction, then if you try to get a license with Child Protective Services can deny giving you a license, or if you have a license, they can revoke or suspend your license. Now, I say that to say this. Let's say you're representing yourself. You decide to represent yourself, and you want to see if you can get probation and to settle your case. And so you talk to one of the prosecutors. And the prosecutor said, well, we're not offering probation, we're going to offer a fine, or we're going to offer a jail term. Well, if that happens, according to this one sentence paragraph, it states that you may change your mind and say, well, judge, I don't want to represent myself. I want an attorney. Okay? That's an option that you have. And as we go on, we'll mention to you other options that you have, even if you're representing yourself. Hey, how you doing? And now at the bottom of this document, in bold letters, it states defendant's choice. Mark initials next to only one choice. Now everybody's gonna make a choice. You're gonna make one of these 5 choices. Everybody here for a case is gonna make a choice. And if you would like to hire your own attorney, you will place your initials on the first line to the left. If you're hiring your own attorney, and then you will sign your name at the bottom where it says defendant, you will date it today's date, April 21st, and then you'll stop. This is the only form you'll have to sign. Okay? You wouldn't have to sign none of the other form. This is the only form you'd have to sign. Now, if you have already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. Okay? That is if you've already hired an attorney. Then you'll sign where it says defendant. You will date it today's date, April 21st, 2026, and then you'll stop. This is the only form you have to sign. Now, if you would like to apply for a court-appointed attorney, then you will place your initials on the third line at the bottom to the left. The third line. Then you'll sign, dated today's date, and then you'll fill out this form that's titled Jefferson County Affidavit of Indians or Affidavit of Indians. And as I mentioned to you earlier, you'll fill out the entire first page. And then when you go to the second page, you will fill out the top portion that's titled Defendant's Oath, and then the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. This is always for people who's applying for a court-appointed attorney. Now, going back to this document, the fourth line on the left is for individuals who have already been appointed a court-appointed attorney. If you've already been appointed a court-appointed attorney, you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Then you'll sign where it says defendant, dated today's date, April 21st, 2026, and then you'll stop. This is the only form you have to sign. If you would like to waive your right to an attorney, that is, you would like to represent yourself, then you'll place your initials on the last line to the left, the fifth line. You will sign where it says defendant, and you will date it today's date, April 21st of 2026. And then you'll fill out this form that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. You'll read this form, sign it and date it, and then you'll stop. Now, before I go any further, do we have any questions? Yes.
She's a minor and she's special needs. If she was to appoint
Well-
herself as counsel,
No. We'll have, we usually have somebody here from Spindletop.
she's her caseworker.
Yeah, but we have a program with Spindletop, where they can do your interview and, well, we'll get around there, so. Thank you, call those folks.
Sir?
Spindletop.
I do, our guys are in training.
Okay. All right. Now, anybody else have a question? Before we go on? Anybody else? Okay. Okay, now, we're gonna give you.
So they can fill them out and actually just keep them.
Yeah.
To the event.
Okay. We can do that at the end. We're gonna give you time to fill out that paperwork. You don't need to fill it out right now. There's some more information that I need to give you. And that is, as a defendant in a criminal case, you have rights. One of the other rights that you have besides the right to have an attorney, you have a right to have a jury trial. Okay? Where Mr. Stewart is sitting, we call that the jury box. In this, there's 12 seats, but in county court at law, you have a 6-person jury. And so 6 people, 6 citizens from Jefferson County will be selected to serve as jurors in your case. And as a jury, they will listen to all the evidence that's presented by the state and by the defense, all of the arguments of the state and the defense. And then they will go back into the jury room to deliberate, and they can decide to find you either not guilty or guilty. Now, you can waive your right to have a jury trial, which means you can give up your right to have a jury trial. If you give up your right to have a jury trial, that simply means that you will not be having a jury trial. You still can have a trial. You would have what is called a bench trial. That is, it's a trial by judge. The reason why they call it a bench trial is because the judge sits on the bench. All right. So you can have a bench trial and the judge will be the judge and the jury in the case. The judge will listen to all the evidence that's presented by the state and by the defense, all the arguments of the state and the defense, and the judge will apply the law or the facts to the law and then decide whether or not you are not guilty or guilty. Now you can waive or give up that right as well. In essence, you can say, well, I don't want to enter a plea. Well, I don't want to have a trial by the judge. I don't want to have a trial by the jury. I just want to enter a plea of guilty to the case or no contest. Now, there are three pleas you can enter. You can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you've been tried, that you have been charged with. Or you can enter a plea of guilty. That means that you're telling the court you committed the offense that you've been charged with. Or you can enter a plea of no contest, which means that you are not contesting or you are not fighting the charge. Now, if you enter a plea of not guilty, then you will have a trial, either trial by judge or trial by jury, whichever one you select. If you enter a plea of guilty or no contest, then you will enter into what is called a plea bargain agreement. Okay? Now, there are two types of plea bargains. One is called an agreed plea bargain. The other type is called an unagreed plea bargain. And as I mentioned to you earlier, if you forgot, a plea bargain is just a way to settle your case. It's a settlement. And so you'll talk to, or you have a lawyer, they'll talk to the prosecutor, they'll make an offer in the case. You can accept it or reject it. If you accept the offer, that means y'all have an agreement. Then the case comes before the judge, and the judge can do one of two things. The judge could accept or reject your agreement. If the judge accepts your agreement, and let's say within 30 days you decide that you would like to appeal your case, and because you have 30 days to appeal your case or file a motion for your trial, you have to get permission from the judge to appeal your case if the judge follows the plea bargain agreement, okay? So if the judge gives you permission, what's going to happen with the case is going to leave this court, and it's going to go to the Ninth Court of Appeals, which is right upstairs. There are 4 judges up there, 4 justices. They will review your case. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty, case over. Or they can send the case back down to this court or to this court to give you a whole new trial. Or if they deny your appeal, guess what? You can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals in Austin, Texas, which is the highest criminal court in the state of Texas. You would have to file what is called a petition for discretionary review. You have to file a pro se petition for discretionary review. And what pro se means is you represent yourself. You by yourself, pro se. And you'll be petitioning or asking the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted, or to see whether or not this court committed an error by convicting you. They can do one or two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. Or if they deny your appeal, or your pro se petition, then at that point, your conviction will stand. Now, the other type of plea bargain, I mentioned to you, you can have an agreed plea bargain. The other type is an unagreed plea bargain. Okay, let's say, for example, you would like to get probation. And let's say you or your attorney talk to the state, the prosecutors, and they say, well, again, we offer a fine. And you say, well, I don't want that. And so you have the option to go to the judge and ask the judge for the type of punishment you want. That's called unagreed. That means you don't have an agreement with the state, and you want the judge to decide what your punishment will be, the judge could go give you any punishment anywhere within the punishment range, okay? That's called an unagreed plea bargain, where you asking the judge to do it, you couldn't come to an agreement with the state. You want to see if the judge would give you what you are requesting, okay? Now, the other thing is, the other right that you have a right to call witnesses. That chair that has the microphone in front of it, that area is called the witness stand. And what witnesses do, witnesses can testify for you or against you. If you're representing yourself, you can ask some questions. Or if you have an attorney, your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you can waive or give up your right to have an attorney, to call witnesses. What that means is if you waive your right to call witnesses, that means that you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have what is called a Fifth Amendment right against self-incrimination. What that simply means is that you have a right not to testify. Okay? The state, the government, the DA's office cannot force you to take the witness. Okay? If you invoke or you exercise your Fifth Amendment right against self-incrimination. I know a lot of times we watch television and we see a lot of these law and order shows that's on television, and you might see the television lawyer go up to a witness stand to ask the witness a question, and the witness say, "I take the fifth." Okay? What that means, I'm zipping it, I'm not saying nothing, and you can't make me say nothing. Okay? If you think about it, it makes sense. Why does it make sense? It makes sense because it is. The state or the district attorney has the burden of proof. What that means is they have to prove that you are guilty beyond a reasonable doubt. You don't have to prove yourself guilty. Okay? That's why it makes sense. You don't have to get up there and say, I did it. You don't have to do that. Right? You have a right against self-incrimination, and they can't force you to take the witness stand. Now, you can waive or give up your right. Now, if you waive or give up your right against self-incrimination, that simply means that you will be taking the witness stand. That's all that means. Okay. You also have a right to have what is called discovery. And what discovery is, you have a right to see the evidence that the state has against you. The state has a file on everybody. On everybody that's been charged. They have file. Okay? You have a right to see the evidence that's in the file. You have a right to see your statements, witness statements, police reports, lab reports. You have a right to see video recordings, listen to audio recordings, see photos, all right, to see documents or any type of instruments that they have. You have a right to have access to that. That's called discovery. Okay, I guess they call it discovery because at that point you're discovering what the state has. Okay? So you have a right to have discovery. Now you can waive or give up your right to have discovery. If you waive or give up your right to have discovery, that simply means that you will not be having access to the evidence that the state will be using against you. All right. Now, everybody that's here for a case, you have been charged with an offense, you've been arrested, placed in a county jail, you bonded out of jail, you're either out of jail on a cash bond, which means you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail. Or you're out of jail on what is called a PR bond or a personal recognizance bond, which means that you didn't have to pay no money to get out of jail. You were released under your own personal recognizance with a promise to appear here today. I said that to say this. Every day that you spent in jail can be used as credit towards your punishment. Now, the operative word is every day that you spent in jail. Now, let's say you were booked into jail 11:59 p.m. on last night. And let's say you booked out of jail at 12:01 a.m., 2 minutes later. Guess what? That's 2 days. Credit. The reason why it's 2 days, because it's 2 different days. Okay? You don't have to be there 48 hours to get credit. You book out that same day, that's 1 day credit. Even if you was there 1 minute. Booked in, booked out, that's a day. So every day that you spent in jail can be used as credit towards your punishment. Now, so for example, let's say you spent 5 days in jail. Talk to the state is offering you 5 days in jail. Guess what? You don't have to do any more time in jail because why? Because you'll be given credit for the time that you have already served. We call that credit for time served. Now, if the state is offering 7 days in jail, you spent 5 days in jail, that means you only have to spend 2 days in jail. Why? Because we'll subtract 5 from 7, that leaves 2. All right. Now, every day that you spent in jail can also be used as credit towards your fine and court cost. Every 1 day that you spend in jail, you are credited $100 per day that can go towards your fine and court costs. So if you spend 5 days in jail, that's $500. State is offering you fine and court costs of $500. Guess what? You don't have to pay anything because the time you spent in jail has already paid it off. Therefore, it'll be taxed and retired. That's what it's called. You already paid it. Now, if they're offering fine and court costs of $700, that simply means you have to pay $200, right? Now, you'll be required to pay $200 on the day that the case is taken care of. If you cannot pay it, no problem. Why? Because we can put you on a payment plan. And you can pay off small monthly installments until it's paid off. Now, let's say we put you on a payment plan. If we put you on a payment plan, you still would not be able to pay it because you do not have the income. No problem. Because we can convert the fine and court costs to community service. And for every 1 hour of community service that you perform at a nonprofit organization, $12.50 will be credited towards your fine and court costs. So in our scenario, if you owe $200, if you work 8 hours in 1 day, that's $100. So you work 2 8-hour days, that's $200 you paid off. Okay? Now, Jefferson County has a program that is called pretrial diversion. Now, when I say Jefferson County, I'm talking about the district attorney's office. The program is called pretrial diversion, and it's for first-time offenders. Now, with the pretrial diversion program, you get into the program, complete the program, then we'll dismiss your case. Then you can get what is called an expulsion. You can get it removed from your record. An expulsion is erased, deleted, or wiped off your record like it never happened. That's the pretrial diversion program. In order to get in the pretrial diversion program, 3 things has to happen. 1, has to be your first time getting in trouble with the law. You can have 1 or more than 1 case, but it's your first time. Okay? And then 2, you have to have a lawyer to help you to get into the program. The lawyer could be appointed. You don't even have to hire the lawyer if you can't afford to hire. The lawyer could be appointed. And 3, it cannot be for an offense of unlawfully carrying a weapon or resisting arrest. So all other offenses, you can apply for pretrial diversion. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program called Veterans Court. It's like pretrial diversion. It's part of pretrial diversion. You get into the program, you have to be a veteran of any one of the branches. You get into the program, you complete the program, you can get an expunged from your record. The case is dismissed. Okay? Only thing you have to do is be a veteran. That's all. It doesn't depend on the type of case. It just depends on your status as whether you're a veteran or not a veteran. Whether you had, so if you're a veteran, that program is for veterans on. This court, County Court at Law number 2 of Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office. The program is called the CSI program. CSI is an acronym that stands for Community Safety Initiative. That program is designed to address the issue of what we call recidivism. I'll explain that to you. Recidivism means people committing crimes over and over. You know, they do one crime, they commit another, they keep getting in trouble. And so the program is designed to address this issue of recidivism. And in that program, we have partnership with various agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center in the Southeast Texas region. They have the expertise to address mental health issues. They have doctors, counselors, and they have facilities and programs that can address mental health needs. You do not have to be incompetent or insane to participate in the program. You can just merely suffer from depression, anxiety, or any other host of mental illnesses. They have the expertise to address the mental health needs. Now, what they will do, they're not here today because I understand they have a training session, but normally they're here on Tuesdays. And what they normally do is have an interview in our jury room, or they can have it at their facility, or they can do it by telephone, or they can do it by text message. Some people just like the text all the time. Okay. And so they can interview you that way, or they also can do what is called an assessment. An assessment means that they will determine what your mental health problem is. And then they can develop a treatment plan for either outpatient or inpatient treatment. Now, if you have issues with drugs or alcohol, well, Spindletop also has a program that is called ATAR. ATAR is an acronym, ATAR, that stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OZAR. OZAR is an acronym, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. And what they will do an assessment, which is like an interview. They will do a screening, which is like an interview. Then they will do an assessment to determine what your alcohol and drug issues are. You got that way. And then they will develop a treatment plan for either outpatient or inpatient treatment. Now, if you are unemployed, or if you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE, and it stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they will help you to get a job in the area that you're trained in. And if you have not graduated from high school, if you do not have a GED, well, Spindletop, as well as the CICE program, has a GED program where you can get your graduate equivalency diploma. Now, all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say in this court, we don't just give time. We take our time. That is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. So I like to say that when you come to county court at law number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their homes. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs that I just mentioned to you, just let us know, and we'll be happy to direct you to the individuals and people that you need to talk to so that you can get on the road to living your best life. Okay? So, as I mentioned to you earlier, well, we have Mr. Johnny Stewart. He's here. He has one of the pretrial diversion programs. He's with Family Services. Family Services has a program that is called Battles Intervention and Prevention Program. It's kind of referred to as BIP. And it's for individuals who have assault cases, or assault family violence cases. And he could tell you more about that program that Family Services has to offer. At this time, Mr. Stewart, would you please come forward?
Thank you, Judge. Good morning. Thank you for allowing me to be here. My name is Johnny Stewart. I'm the BIP Director of Batteries Intervention and Prevention Program. This is what we call the domestic program. With Family Services of Southeast Texas. You probably know us from our homeless shelter, women and children's, now men's shelter. But we also have a program for the first time batters. So if you're interested in that, it's a 8-2 program through all classes. What we do is we work on changing behaviors. It's men's and women's that are involved in these programs. We have separate groups. We also have groups for if you're working, we have Zoom groups, those virtual groups, but we also have in-person groups here in Beaumont on Wednesday. So we try to work around the schedule if you're working. But if this is your first time that you've been here on a domestic violence charge or a family violence charge, please take advantage of this program, because we're trying to change behavior not only for yourself, but also for your families. So other programs that we offer is also our non-residential program. Those are for the victims. So if you know any victims, we also have our programs. But try to get in this program so we can avoid you coming back here for the same thing. So if you need any information, we have brochures right over here. It's Family Services, and I'm going to put them over there. Let the ADAs know that you're interested in that program, and we're trying to get you in our program and get you get some of the documents. Okay. Thank you so much for allowing me to be here.
Okay, thank you, Mr. Stewart.
Thank you, Judge.
Now, ladies and gentlemen, the program that Mr. Stewart has, that's part of pretrial as well. So if you complete that program, your case is dismissed, and you can get it expunged off of your record. Okay. Now he says that they're trying to change behavior, and the reason why they're trying to change behaviors is because they're saying that the parent's biography becomes a child's biology. In essence, if they see it, they'll be it. In essence, when they see things, they internalize it, and they become, in essence, they start doing those same things that they see. And so if they can break the cycle, then it won't occur in the following generation. So that's what he's talking about. Okay. So now, ladies and gentlemen, we're going to give you a few more minutes to finish filling out that paperwork. We're going to pick up the paperwork from you. We're going to put you in one of 3 categories. One category is you want to hire your own attorney. If that's the case, your case will be reset today, and then you'll leave. The second category is if you want to apply for a court-appointed attorney, if you qualify for a court-appointed attorney, your attorney will be appointed today before you leave. And the other thing is, the other category is if you like to represent yourself, then you'll have an opportunity to talk to the prosecutor And if you're able to work out an agreement, your case will be taken care of today. And as I mentioned to you earlier, you can have an opportunity, if you represent yourself, to talk to the prosecutor. The other option is, if you don't come to an agreement, you have an option to go to the judge where he can set punishment, or you can, request that an attorney be appointed to represent you, okay? So those are some of the options that you have. Before we go into recess, I need to remind you that, one, we're still in court, so you need to conduct yourself accordingly. Two, there are two restrooms out there in the hallway. If you need to use the restroom, the men's restroom is in front of County Court at Law number 3, which is right next door. And on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. You'll be allowed to go into halls to use the restroom. Once you use the restrooms, please come back into the courtroom. Do not leave the courthouse. If you leave the courthouse, your case is called, not here, guess what? Your bond is gonna be forfeited. Warrant gonna be issued for your arrest. You will be arrested, placed in the Jefferson County Jail, and guess what? We're gonna have to go through this all over again. So we don't wanna do that. We wanna try to get you in and out as soon as possible. Yes, you had a question?
I'm just finding out.
In the courthouse?
Not in Indiana, but outside somewhere.
Not in the courthouse, you know, maybe one of the restaurants or something, I don't know. Yeah, we don't have nothing here. Yeah, they used to have a restaurant downstairs, but it's no longer open. And honestly, they don't have the coffee machine. Anybody else have any questions? Yes.
I was just trying to figure out what would be the best option for her. She goes to represent herself with her being special needs.
Well, I don't think that would be a good option. And because if she represents herself, she's gonna be held to the same standard as a lawyer. So, but we need to, what we'll do, Bill, just sit tight, just, bring her back. We usually have some folks in Spindletop that's here, they're in training today, and so they're not here. But we'll deal with that. Anybody else? Okay. Anybody else have any questions? Now, once you finish with the paperwork, we're gonna call you up and put you in one of the 3 groups. We're gonna call you up here. We have our co-personnel as well as myself, who will be assisting you with filling and completing the paperwork, okay? So at this time, the court will be in recess. Jefferson County Court at Law number 2 is now in session. The court is in session with the initial review docket or the initial appearance or the arraignment docket. First case is, well, first two cases are cause numbers 25 CCCR 0312 and cause number 25 CCCR 0313. Both cases are styled the state of Texas versus Ariana Gassaway. Ms. Gassaway is appearing via Zoom. Ms. Gassaway, when is the case reset to? May 5th. Okay, Ms. Gassaway, your case is reset until May 5th of 2026. On that day, you need to be in court in person. Stay in contact with your bondsman. Again, it's May 5th, 2026 at 9 a.m. You need to be in court in person. Stay in contact with your bondsman. You're free to go, and you have a blessed day.
You too, thank you.
Okay. The next case, the next two cases are cause numbers 26 CCCR 0060 and cause number 26 CCCR 0061. Both cases are styled the state of Texas versus James C. Hendricks. Mr. Hendricks, would you please come forward? Mr. Hendricks, your full name is James C. Hendricks?
Yes.
Mr. Hendricks, would you please raise your right hand? Mr. Hendricks, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Hendricks, you may put your hand down. How are you doing, Mr. Hendricks? Good. You doing good? That's good. Now, Mr. Hendricks, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that states you'd like to have your case reset to hire your own attorney?
Yes.
Now, Mr. Hendricks, before you signed and initialed this document, did you read the document?
Yes.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Hendricks, your cases will be reset. Our court coordinator will reset your cases. Once your cases are reset, you'll be free to go and you have a blessed day. Please stand and have a seat in that first chair on the wall right there. Next case is cause number 24 CCCR 1714. Case is styled the state of Texas versus Darrell James Martin. Mr. Martin, your full name is Darrell James Martin.
Yes, sir.
Mr. Martin, would you please raise your right hand? Mr. Martin, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Martin, you may put your hand down. How are you doing, Mr. Martin? Doing fine, that's good. Now, Mr. Martin, I have before me the document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that states you'd like to have your case reset to hire your own attorney?
Yes, sir.
Before you signed and initialed this document, did you read the document?
Yes.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Mr. Martin, your case will be reset to give you an opportunity to hire your attorney. Our court coordinator is going to reset your case. Once your case is reset, you'll be free to go and you have a blessed day. Please have a seat in that second chair on the wall. Next case is cause number 25 CCCR 2512. Case is styled the state of Texas versus Michael Clay Court.
Hendricks. You can sign in the chair for me. Your stuff, your belongings, put it in chair for me.
How you pronounce your last name?
Kurt.
Kurt?
Yes, sir.
Mr. Kurt, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Kurt, you may put your hand down. How are you doing, Mr. Kurt?
Doing good.
That's good. Now, Mr. Kurt, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney, but you need this one. And do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Or are these your initials on the line that state
Yes, sir.
you would like to have your case reset to hire your own attorney?
Yes, sir.
Now, Mr. Kurt, before you sign and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Kurt, your case will be reset to give you time to hire an attorney. Once your case is reset, you'll be free to go and you have a blessed day and have a seat in that second chair on the wall. Wilson Levant White. Okay, Mr. White, your full name is Wilson Levant White.
Yes, sir.
Mr. White, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. White, you may put your hand down. How are you doing, Mr. White?
Very much.
I'm doing fine, thanks for asking. Now, Mr. White, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled defendant? Are these your initials on the line that state you'd like to have your case reset to hire your own attorney?
Yes, sir.
Now, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? And Mr. White, I read your answers. Your case will be reset to give you an opportunity to hire an attorney. But before you go over to the window to have your case reset, I need to give you some bond conditions. The bailiff is going to hand you a document that's titled Standard Bond Conditions in County Court Law Number 2. Do you see that document? Okay, I'm going to go over this document with you, and it states, following return of criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number, let's see, right. Condition number 3 and condition number 4 does not apply. However, condition number 5 on page 2 does apply. And condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. White, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Yes, sir.
Now, Mr. White, you can have a seat in that second chair on the wall, or the first chair, and wait for your name to be called. Emil Javin Alexander. Mr. Alexander, your full name is Emil Javin Alexander? Javon? Okay, Mr. Alexander, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Alexander, you may put your hand down. How are you doing, Mr. Alexander? I'm doing fine, thanks for asking. Mr. Alexander, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. And do you recognize this document?
Yes.
Is this your signature on the line that states you like to, that's titled defendant?
Yes.
Now you have are these your initials on the line that states you like to have your case reset to hire your own attorney? Okay, now, Mr. Alexander, before you sign and initial this document, did you read the document?
Yes.
To understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Alexander, I read your answers. Your case will be reset to give you an opportunity to hire an attorney. And our court coordinator will give you reset, but before she gives you the reset, the bailiff is going to hand you a document that's titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Yes.
Okay, I'm going to go over this document, which in the states. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 does apply, and it states, the defendant shall not communicate, either directly or indirectly, with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that
Yes.
condition? Now, condition number 4 does not apply, however. Condition number 5 does apply, and condition number 5 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer, as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Alexander, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand? Now, Mr. Alexander, that door is locked, sir. Only one door is open. And you can have a seat in that chair, wait for your name to be called. Once your name is called, go to the window. And once you finish at the window, you're free to go and you have a blessed day. And by the way, you look nice today. All right.
You can have a seat on my car, get back up.
You know, they always say dress for success. Cassandra Treviso. Miss Treviso, your full name is Cassandra Monique Treviso?
Yes.
Miss Treviso, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Treviso, you may put your hand down. How are you doing, Miss Treviso? I'm doing fine, thanks for asking. And Miss Treviso, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these initials on the line that state you'd like to apply for a court-appointed attorney? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of this same document, there's a setup. There's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes.
Now, Miss Treviso, before you sign and initial these documents, did you read the documents?
Yes.
And did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Ms. Treviso, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you, in this case, is Attorney Don Boudreaux. Attorney Boudreaux will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Avery Davis. Mr. Davis, your full name is Avery Davis. Mr. Davis, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Davis, you may put your hand down. How are you doing, Mr. Davis? I'm doing fine, thanks for asking, Mr. Davis. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that states you like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yeah.
And on page 2, there's a signature above the line that is titled Defendant's Signature. Is this your signature? Now, Mr. Davis, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Davis, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Tom Burbank. Attorney Burbank will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you'll be free to go, and you have a blessed day. Thank you. You're welcome. Jared Wesley Gaucher. Ms. Gaucher, your full name is Jared Wesley Gaucher.
Correct.
Ms. Gaucher, would you please raise your right hand? Do you swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Gaucher, you may put your hand down. How are you doing, Mr. Gaucher?
As well as I can be with about this.
I'm doing fine. Thanks for asking. Mr. Gaucher, I have before me a document. Actually, I have two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, Your Honor.
At the bottom of this document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, Your Honor.
And there are a set of initials on the line that state you like to apply for court-appointed attorney. Are these your initials?
Yes, Your Honor.
I also have another document that is titled Trial Court, that's titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, Your Honor.
On page 2 of this same document, there is a signature above the line that's titled Defendant's Signature. Is this your signature?
Yes, Your Honor.
Now, Mr. Gaucher, before you sign and initial these documents, did you read the documents?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Okay, Mr. Gaucher, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Christy Kaufman. Attorney Kaufman will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information, but before she gives you that information, I need to give you some bond conditions. Bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that document?
Yes, Your Honor.
I'm going to go over this document with you, and it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or order subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, Your Honor.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, Your Honor.
Condition 3 and 4 does not apply. However, condition number 5 does apply. Condition number 5 on page 2 states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Mr. Gaucher, do you understand that condition?
Yes, Your Honor.
Now, Mr. Gaucher, If you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. Do you understand that?
Yes, Your Honor.
Okay? And by the way, you look nice today too.
Appreciate you.
All right. Now, Mr. Goshe, you're gonna have a seat in that chair, wait for your name to be called. Once your name is called, go to the window, and once you finish at the window, you're free to go. You have a blessed day.
You as well.
Okay. Genesis Elmore. Okay. Your name is Genesis Elmore. How are you doing? That's good. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, you may put your hand up. Now, I have before me a document, two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initials online that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? And on page 2, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Giles Cole. If you were, Giles Cole were here, he was here early. He was a tall gentleman. He, yeah, no, not him. It was another gentleman. He came in with a young lady earlier.
He had like some dreams.
Yes, that's Giles Cole. Now, Mr. Cole will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go and you have a blessed day. Please have a seat in that second chair on the wall. Adrian Travis Brooks Jr. Mr. Brooks, your full name is Adrian Travis Brooks Jr. Mr. Brooks, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. How are you doing, Mr. Brooks? You doing good? That's good. Now, Mr. Brooks, I have before me two documents. The first document is titled Judgment Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? Now, Mr. Brooks, before you signed and initialed all of these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Now, Mr. Brooks, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Jennifer DeLage. Attorney DeLage will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information, but before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. I'm going to go over this document with you, and it states as follows. Following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds are executed for release of any defendant named herein, or orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And let's see, Brooks. Condition 3 and 4 does not apply. However, condition number 5 does apply. And it states defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Now, Mr. Brooks, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that?
Mhm.
Okay, Mr. Brooks, you're gonna have a seat in that second chair. Wait for your name to be called. Once your name is called, you go to the one, and once you finish the one, you're free to go, and you have a blessed day. Sierra Coleman,
Are you okay with?
she can come with her. Yeah, that's fine. Okay, now we have 2 cases. Cause number is 25 CCCR 3010 and cause number 25 CCCR 3011. Both cases are styled the state of Texas versus Sierra Nicole Cole. Ms. Coleman, is that your full name?
Yes.
How are you doing, Ms. Coleman? You're doing good. Thumbs up. Now, Ms. Coleman, you're here with someone, and who do you have with you? Your mother? Okay, ma'am. Thanks for coming down here with your daughter.
Oh, thank you. You're welcome.
Okay. Now, Ms. Coleman, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the document?
Yes, sir.
And are these your initials on this document?
Yes, sir.
That on the line that states that you like to apply for court-appointed attorney. I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes.
Now, on page 2 of this same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes.
Now, Ms. Brooks, before you sign and initial these documents, I see your mother here, and your mother help you to fill out the documents. Is that correct?
Yes, sir.
Okay. Now, is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay.
Yeah.
Now, Ms. Brooks, excuse me, Ms. Coleman, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. And our court coordinator will give you that information, but before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law number 2. And I'm going to go over this document with you. Okay. Now, it states following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are orders subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. So you can't break the law. Do you understand that?
Yes, sir.
Number 2, defendant shall submit to testings for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and a test indicates the presence of drugs and alcohol in the defendant's body. And what that means is I can order that you take a drug test.
Yes, sir.
And if you refuse to take the drug test, we can revoke your bond, which means you can be placed in the Jefferson County Jail. Or if you take the drug test and you fail the drug test, you could be placed in the Jefferson County Jail because your bond will be revoked. Do you understand that?
Yes, sir.
All right, now, this next condition, number 3, states that defendant shall not communicate either directly or indirectly with the alleged victim. When we say communicate, talking, that could be social media, it could be by telephone, no form of communication with the victim.
I'm the victim.
Okay? Okay, so that's so in that instance, what we'll do is this here, state. We'll just say that she cannot communicate with you in a threatening or harassing manner.
Okay.
Is that correct?
That's correct, Your Honor.
Okay. Communicate. And she lives with you, is that correct?
Yes, sir.
And then, so we're gonna do this here. We're gonna strike out the part that says she can't live in any residence. Okay, so you cannot talk to your mother in a threatening or harassing manner.
Yes, sir.
You understand that?
Yes.
And number 4 does not apply, however, number 5 does apply. And it states that the defendant is prohibited from possessing a firearm. Firearm is a gun, okay, or ammunition, bullets, unless the defendant is a peace officer, unless you're a police officer or a peace officer, as defined by 1.07 of the Penal Code. That's what a law is found. Actively engage in employment as a sworn full-time paid employee of a state agency or political subdivision. So if you're not a peace officer, actively engaged, and if you was full-time and sworn in, if you don't fulfill that requirement, you can't possess a gun or ammunition. Do you understand that? Now, if you violate any one of these conditions, your bond can be revoked, then you're out on bond. And if your bond is revoked, a warrant could be issued for your arrest. You could be arrested and placed in the Jefferson County Jail.
Yes, sir.
Do you understand that?
Yes.
All right. Now,
I'm gonna change this. Did you wanna move something out?
oh yeah, what we do, take that. No, we're gonna make a copy of what I just did.
Okay,
We could tear that one up.
okay.
We're gonna give you the one that I made the corrections on, okay? Now, there are some people, did she fill out that form?
Yes, yeah, I got it.
Okay, and so we're gonna have some, your attorney, is Mr. Faggart. And you probably need to, well, you're gonna go with him when she goes talk to him. And you just fill him in on everything.
Right.
And he knows what to do. Okay? All right. Your case is gonna be reset. You're gonna be, and then once you get your reset, you're free to go and you have a blessed day. All right. Okay, who else what's this? Skinner. Thomas Skinner? Who's that? Oh.
How you doing?
How you doing, Mr. Skinner? Now, Mr. Skinner, your full name is Thomas Craig Skinner, is that correct?
Sir.
Excuse me. 1 minute. Okay. Mrs. Skinner, you raise your right hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may put your hand down. And again, Mr. Skinner, how are you doing?
Great.
You doing great? That's good. Now, Mr. Skinner. Hmm?
Missing work, but yeah, I'm okay.
Yeah, we have to take care of some things. Sometimes we're required to miss because of the things we have to take care of. Now, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Right.
And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled that's titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes. Yeah.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Skinner, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, Your Honor.
Mr. Skinner, I've read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney David Grove. Attorney Grove will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please stand in front of the court coordinator. Okay, here you go.
Holmes?
The lead Darvish.
You got anything, sir?
I'm doing fine, and your full name is Khalid Darwish.
Yes.
Mr. Darwish, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Darwish, you may put your hand down. How are you doing?
Good, how about yourself?
I'm doing fine. Thanks for asking. Now, Mr. Darwish, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes, sir.
And are these your initials on the line that state you like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
Okay. On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Darwish, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Sorry?
Did you understand what you read?
Yes, sir.
And is everything in these documents are true and correct to the best of your knowledge?
Yes, sir.
Mr. Darwish, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in your case is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Thank you.
Please have a seat in that second chair on the wall. Let's see. Man. Goodness. How that trying? Okay. This is cause number 23 CCCR 2062, case of style of state of Texas versus Khalees D. Flowers. Mr. Flowers, is that your full name? Mr. Flowers, would you please raise your right hand? Do you swear, affirm, and tell the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Mr. Flowers, you may put your hand down. How are you doing, Mr. Flowers? That's good, Mr. Flowers. You have a right to have a record made of this proceeding. That what that means is you have a right to have a court reporter to sit down and type down everything that's being said. You also have a right to waive your right to have a court reporter. That means you have a right to give up your right to have a court reporter, to dictate everything that's being said. Do you waive or give right to have a court reporter? You do? All right. Now, Mr. Flowers, I have before me on paper a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you like to waive your right to an attorney to represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line that's titled Defendant? Now, Mr. Flowers, I also have before me on my computer a document that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Khalees D. Flowers, on or about January of 2028 of January 28 of 2023, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, Jefferson County, Texas, that you committed Class A misdemeanor offense of driving while intoxicated with an alcohol concentration level of 0.15 or more. Mr. Flowers, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Flowers, how do you plead? Guilty, not guilty? Guilty? Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Flowers, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment, was also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. First set of initials are on a line next to a box that's checked guilty. Did you place your initials here?
Yes, sir.
Second set of initials are on a line next to a statement that reads as follows. I do not request discovery in this case. I waive my right to request discovery and choose to enter a plea of guilty or no contest. Did you place your initials in the second location?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Flowers, before you sign and initial all of these documents that I'm showing, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Flowers, are you a citizen of the United States?
Yes, sir.
State.
Stay on for 6-1.
Okay, Mr. Flowers, the state is offering State's Exhibit Number 1 to be used as evidence against you in this case. State's Exhibit Number 1 is the first document that I showed you on the tablet. It is the same document that has your initials in these two locations, and it has your signature on page 3. Is it all right for the state to use this document as the evidence in your case?
Yes, sir.
Okay, no objections. State's Exhibit number 1 is admitted. Now, Mr. Flowers, is there any evidence that you are currently mentally incompetent to stand trial? Do you have any mental illnesses? No, no. Listen what I said. Is there any evidence that you're currently mentally incompetent?
No, sir.
Okay. Now, Mr. Flowers, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement in this case is the 365 days jail with credit for 365 days, time served, court costs, tax and retirement in this case.
Okay, Mr. Flowers, the state is offering that you serve 365 days in the Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail because you've already served 365 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. What that means is you would not be required to pay the court costs because the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Flowers, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Mr. Flowers, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Flowers, this will conclude your case. You're gonna stand at the end of the table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day. All right. Now, Mr. Flowers, how long have you been out?
2.5 months.
Okay, are you working?
Yes, sir.
Okay. You're gonna have to pull your pants up, Mr. Flowers. Yeah. Okay. Willie.
I said, you.
Curtis Wayne Simon. What's the dismiss? How are you doing, Mr. Simon? Your full name is Curtis Wayne Simon, is that correct? Mr. Simon, would you please raise your right hand? You swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God. Simon, you may put your hand down. Mr. Simon, where's this page? No. Okay, Mr. Simon, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Is this your signature? Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purpose of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Simon, before you signed and initialed these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Okay. Now, Mr. Simon, I have before me a document in this case that's titled Motion to Forfeit. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Simon, before you signed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Simon, I'm going to grant the order to forfeit the weapon in this case to the Port Arthur Police Department. And state, do you have an additional motion?
Yes.
And your motion to dismiss, is that correct?
Yes, Your Honor.
Okay, Mr. Simon, state has filed a motion to dismiss this case for forfeiture of the weapon. In this case, I will be signing this motion. Once I sign this motion, you'll be able to get a copy of this motion. And once you get a copy of this motion from the court coordinator, you'll be free to go. And you have a blessed day. All right. All right, just please, have a seat and wait for your name to be called. Raya Lene Young.
Something happens when you go anywhere.
Did I pronounce your first name correct?
Yes, sir.
Miss Young. Would you please raise your right hand? Miss Young, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Miss Young, you may put your hand down. And again, Miss Young, how are you doing?
I'm blessed, how are you?
I'm blessed as well. Thanks for asking. Now, Miss Young, the state is represented in this case by Mr. Fred Vernon. Mr. Vernon, how are you doing?
I'm well, sir. How are you?
I'm doing fine. Thanks for asking. Now, Miss Young, I have before me, now, before we get started, Miss Young, you have a right to have a record made of this proceeding. That is, you have a right to have a court reporter to type down everything that's being said. You also have a right to waive, which means to waive the record. You have a right to give up your right to have a record. You waive or give up the right to have a record. You waive, okay. Now, Ms. Young, I have before me on paper a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line,
Yes,
Mr. Defendant? Ms. Young, I also have a document on my computer that is titled Information Sheet. This information sheet was filed by the Jefferson County District Attorney's Office. In this information sheet, it alleges that you, Ryan Lene Young, on or about January the 3rd of 2024, while you were in Jefferson County, Texas, that you committed Class A misdemeanor offense of resisting arrest, search, or transportation. Ms. Young, you understand what you've been charged with?
Yes, sir.
To this charge, Ms. Young, how do you plead? Guilty, not guilty, or no contest? No contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Young, I also have before me a document that is titled Misdemeanor Plea Admonishment, also labeled State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there are two sets of initials. First set of initials are on the line next to the box that's checked for contendere. Did you place your initials in this location? Second set of initials is next to a statement that reads, I waive my right to discovery. I do not request discovery in this case, and I choose to enter a plea of guilty or no contest. Did you place your initials in this location? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? And Ms. Young, before you sign and initial all of the documents that I showed you, did you read the documents? Is you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Young, is there any evidence that you are currently mentally incompetent to stand trial? Ms. Young, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, sir. The parties have stipulated to a 1 year deferred adjudication, $500 fine and 50 hours of community service.
What's the court cost in this case?
77.
$16.92. Okay. Ms. Young, state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 for court costs of $277. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, and reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $154 a month. Will you be able to pay the $154 a month?
No, I'm working on getting a job now.
Okay. Do we have does she have an affidavit in her file?
It was a magistrate from another county, so. they don't
Oh.
even have it. But she
Okay.
told me-
We have one up there. What she's gonna do is she's gonna give you an affidavit. You can fill out that first page. That affidavit contains your financial information. And then I need to see that. And then once I get that information, we'll be able to go forward.
Oh,
All of those.
Yeah.
no. Nobody.
Let's see. There's Willie Samuels Barado. Is that correct? Mr. Barado. I have before me a document that is titled. Well, first of all, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Mr. Barado, you may put your hand down. How are you doing, Mr. Barado?
I'm okay, are you?
I'm doing fine. Thanks for asking. Now, Mr. Barado, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes,
Or are these your initials on the line that state you would like to waive your right to attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
yes, sir.
And is this your signature on the line that's titled Defendant? Now, Mr. Barado, before you signed and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Barado, I understand that you talked to the state about your case. Is that correct? Y'all reached an agreement?
Yes, Your Honor.
Okay, and Mr. Hubel, what is that agreement?
The agreement's to a fine only. The state would be asking and jointly with the defendant for 30 days to accumulate funds to pay that fine.
Okay, well, how much is the fine?
Fine is $600. He has credit for he has credit enough to cover that, but not completely the court costs. That's what he needs time for.
Oh, how much is the court? Well, court cost is usually like $277. Okay. How much time do you need to get to 277?
2 weeks.
2 weeks? Okay, we reset it for 2 weeks. Okay. So your case is gonna be reset for 2 weeks? You're gonna get your reset from our court coordinator? Once you get your reset, you're free to go and you're blessed. Yes.
I got one question. I started work in my new job at the end of April, like April 30th. It's gonna be actually out of town. So could I
Yeah.
possibly make a payment over the phone or do it?
No, you have to be in person.
to be in person?
Yeah, unless you want to do it before you leave town.
I might have to do that because I'm going all the way to Indiana.
Oh, yeah.
Yeah.
So, let's see. You say
April 30th.
you leaving on when?
April 30th.
What is when corporate what's before the 30th? Is it when court on the 29th? Could you have it by the 29th?
Yes, sir.
Okay. We're gonna do it on the we're gonna do it on the 29th. Okay?
Reset to pay,
Yeah, he has about 6 days. How much days credit? Got 6 days credit?
He actually has 7.
Oh, so you only probably gonna need $177.
Mhm.
Cause you got
What if I can come in, if I can get the money today?
yeah, you can come in and pay it.
Okay, I'm gonna do that.
Yeah,
Do that.
okay.
Yeah, I'll do that, just to get it out.
I'm gonna still go ahead and reset it, but if you come in and.
You could just leave him on there so you won't have, if you reset it, she gonna have to put it back on the docket.
I'll put it back, no big deal.
Okay, so how much time, what time you wanna do it this afternoon?
You don't say.
What time is it about? Y'all leave at 5?
You better come in.
You gotta come a little, yeah,
You
yeah.
have to do paperwork and all that stuff.
Yeah, cause we gotta do paperwork, yeah.
Don't hold me back in here.
What about 3 o'clock?
3 o'clock? Okay.
That's good?
Yeah,
That's good with y'all?
Yes, sir.
Okay,
All right,
let's do this, we're gonna hold off to
Yes.
3 o'clock.
Yeah, I'm gonna wait.
Okay,
Okay.
all right, we'll see you at 3.
Okay, thank y'all.
All right. That, okay, yeah. Oh, we can just hold on to this. Miss Young? Come on.
I have a question about it, because, y'all know, I'm not working right now, but I had got money from my dad passing, and that's how I'm able to pay my bills.
Zero.
Yeah,
Why don't you just let us know what you got? I mean, we'll see.
I'm sorry, I'm reading all in front of you.
Okay. Oh,
You got 7 days.
okay. We need to put a false number. Now, Miss Young, I have before me a document that is titled Affidavit of Indigence. Do you recognize this document?
yes, you,
Now, you signed it, okay. Is everything in this document true and correct to the best of your knowledge?
yes,
Okay. Okay, let me do this here. So, no income, you got inheritance. That's, we have 2 kids. Okay, there. So your spouse not working either?
no, he just lost his job. Like,
Okay. Wow. And I'm sorry to hear about your dad. Okay, you have my condolences.
thank you.
Okay, now, let's see. Let me do this here. Okay, Miss Young, the court is gonna find that you're indigent. Okay, Miss Young, the court is gonna find that you're indigent based on the finding of indigency. The fine of $500 plus court costs of $277, which comes to a total of $777, will be converted to 62 hours of community service. The reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. The probation fee of $60 in this case will be reduced to the statutory minimum of $25 a month. You will be required to pay the $15 a month for the reimbursement fee. Your total monthly installments in this case will be $44 a month. Okay. Now, you will also be required to perform 50 hours of community service in addition to the 62 hours of community service, which comes to a total of 112 hours of community service. Do you understand that?
Yes, I do.
And you will be required to adhere to the other standard terms and condition of this probation. Ms. Young, do you understand the state's offer and the findings that the court have made in this case?
Yes, Your Honor.
Now, Ms. Young, do you accept the state's offer?
Yes,
And Ms. Young, do you think that the state's offer in your case is fair and just?
yes,
Well, Ms. Young, I'll follow the plea bargain agreement that you have entered into with the state. Now, Ms. Young, if you successfully complete this probation off, this case will be dismissed. It would not result in a conviction in your record, and you may qualify for a non-disclosure, whereby your record will be sealed to the general public. You can talk to an attorney about the non-disclosure. Okay? Just have a seat, wait for your name to be called because we have to redo the paperwork. Yes, ma'am.
Did you say reimbursement fee waived? You did, right?
Yes,
Okay.
pursuant to 102.018 Texas Code of Criminal Procedure.
Okay.
And
Thank you.
62 hours of community service. The statutory minimum. Jefferson County Court Law number 2 is back in session. The court is in session and calls number 25 CCCR 2308, case of South State of Texas versus Vedrick Blackwell. Vedrick Blackwell is scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's barely called the name of Vedrick Blackwell at the courthouse door. Vedrick Blackwell did not answer. Vedrick Blackwell has not appeared in court since the court has been in session. The time now is 12:28 p.m. on today's date of April 21st of 2026. Ms. Bailey, would you please call the name of Vedrick Blackwell at the courthouse door?
Vedrick Blackwell, Vedrick Blackwell. No response, John.
Okay, Vedrick Blackwell's name was just called again at the courthouse door. Vedrick Blackwell did not answer. Reasonable time has passed to give Mr. Blackwell an opportunity to appear in court. State, you have a motion?
Yes, Your Honor. The state motions for bond forfeiture.
Okay, Vedrick Blackwell, well, that motion will be granted. Vedrick Blackwell's bond will be forfeited and warrant should be issued for his arrest and cause number 25 CCCR 2308. And this will conclude the calling of the court's initial appearance docket on today's date, April 21st, 2026. In County Court Law number 2, Judge Terrence Holmes presiding. Everyone, please have a blessed day. Prosecutors, you are excused.
Thank you, Your Honor.